Hello everyone, my name is Shivangi Agrawal, your law mentor, and today I am here for a quick discussion on MQP, right? Model question paper, CMA final law relevant for I shouldn't say, but yes, of course, it has been released for December 24 term examination. This is set one with me. This particular paper is only the questions, although the suggested answers have also been released by the institute. Now, what am I going to do in this particular video? It's a quick discussion, right? Explaining you all the questions in brief, covering your major queries which have been asked over the period of time, explaining you the pattern and the approach, how you should do, what you should write in a particular answer, how the step marks are being awarded and all that, right? So let's begin. The paper pattern is firstly the same, right, as has been asked in the past term, as has been released in past MQP. तो पेपर पैटर्न में कोई भी चेंज नहीं है, एकदम सेम एज इट इज पूछा गया है. There are two sections. Section A, which is of course compulsory and consists of MCQs. तो 13 marks है. अब although when the students look at the marking scheme, which is quite surprising, but it has been like that in the past also. Every question is of 2 marks. तो आपका सवाल सबसे पहला यही होता है, मैम, do we need to write the justification? Because earlier you used to write the justification. Now you're not required to write the justification. Although लिख दोगे तो कोई हार्म नहीं है, बट आई वुड अगेन इंसिस्ट, बिकॉज इट हैज बीन मेड वेरी क्लियर बाय द इंस्टीट्यूट. भाई मेरे पास इतनी कॉपियां हैं, आई हैव सो मेनी आंसर कॉपीज, द स्टूडेंट्स हैव क्लियरली रिटन A, B, and they have been awarded full 2 marks. So no two ways about it. Please save your time and energy. Don't write unless it is being asked. So institute might surprise you. If it is simply written, choose the correct option. Please choose the correct option. No need to give any justification. Save your time, save your energy for the much demanding descriptive section. Okay. So that is the one thing. That is one thing, right? Then we have section B, out of which you will be given immense choice, not just one but 2, right? So you have been given 7 questions, out of which you have to attempt any 5 questions, right? Now these 5 questions, make sure that you are not attempting like part A of question number 5 and part B of question number 6. So that will not be counted. You have to choose any 5 questions and attempt for the same. Every question is divided into 2 parts. Every part carries 7 marks. So there are 5 questions, 14 marks each, which comes out to be 70. So that is how exactly the paper pattern is. Now let's begin without wasting any more time. So first we'll look at section A, compulsory section of MCQ. So we only have to choose the correct option, yet I will be quickly discussing with you why it is so, right? So minutes of the board meeting are to be signed by, although here we are talking about minutes of board meeting and not minutes of general meeting, but for the minutes we have the same section, right? So हमारे पास सेक्शन क्या है, सेक्शन 118 है, जिसके बारे में हम मिनट्स के बारे में भी बात करते हैं, और हमारे पास सेक्रेटेरियल स्टैंडर्ड भी है, ऑल्दो दैट इज नॉट रिक्वायर्ड. इतना कोई टेक्निकल सी बात नहीं है, बहुत ही सिंपल सी चीज़ है कि जो मिनट्स होते हैं दे आर साइंड बाय द चेयरमैन, साइंड एज वेल एज डेटेड बाय द चेयरमैन, या तो उसी मीटिंग का या फिर हमारी अगली मीटिंग का, नेक्स्ट मीटिंग का, राइट? सो इट इज गोइंग टू बी साइंड एंड डेटेड बाय द चेयरमैन ऑफ द मीटिंग और ऑफ द नेक्स्ट मीटिंग. सो दिस इज द करेक्ट आंसर. सिंपल. SFIO stands for a very simple question. Once again, what is SFIO? कहाँ पढ़ा है, कौन से चैप्टर में पढ़ा है, कौन से सेक्शन में पढ़ा है? दिस इज सेक्शन 212 ऑफ कंपनीज एक्ट 2013. व्हाट इज SFIO? SFIO इज सीरियस फ्रॉड इन्वेस्टिगेशन ऑफिस. इट्स नॉट एग्जैक्टली इन्वेस्टिगेटिंग, बट ठीक है, इन्वेस्टिगेशन ऑफिस हम बोलते हैं, बट यहाँ पे इन्वेस्टिगेटिंग ही दिया हुआ है, बट दैट इज ऑल्सो करेक्ट. ठीक है, तो करेक्ट आंसर तो हमारा यही है. अब ऐसे वहां पे नहीं सोचना है, ठीक है. Now, what is it basically? This is an organization which comes under Ministry of Corporate Affairs. Why is it has been made? What is it? It is some group of people, right? They have been given and conferred a lot of powers under or through Companies Act 2013. और ये लोग क्या करते हैं भाई? They carry out investigations. What type of investigations? जैसे हमारे पास होता है कि नॉर्मल क्राइम को इन्वेस्टिगेट करना है तो पुलिस अथॉरिटीज कैन डू इट. जब कुछ स्पेशल फ्रॉड या बहुत कॉम्प्लिकेटेड सा केस हो जाता है, इट इज बीइंग डायरेक्टेड टू CBI. लाइकवाइज वी हैव SFIO, राइट? तो हमारे पास पूरा का पूरा बेहतरीन सा कि जब रजिस्ट्रार या ROC या इंस्पेक्टर प्राइमा फेसी जो हमारे रिपोर्ट देता है अंडर सेक्शन 208, तो उसके बेसिस पे या बहुत सारी चीजें हमने देखी है वेयर देयर इज सीरियस फ्रॉड, Central government may assign the case to SFIO. Third है हमारा, if the company wants to punish an employee or officer of the company, it has to take permission of. भाई किसकी permission लेनी होती है? पहली बात तो मैम ये question आ कहाँ से रहा है? From where it is coming, right? So we have read a section called as section 218. Wherein we talk about the protection of employees. What if the employees cooperate? What if the employees tell certain things? The company will actually fire them. If not fire them, maybe suspend them, maybe demote them, right? तो आप उनके साथ कुछ भी ऐसा हार्श चीज नहीं कर सकते हो. सो इफ यू वांट टू पनिश एन एम्प्लॉय और ऑफिसर ऑफ द कंपनी इन जेन्युइन केसेस कि सच में हमें तो इसको डिमोट करना है या इसको कुछ करना है, इट्स नॉट बिकॉज ऑफ दैट. यू नीड टू सीक परमिशन ऑफ एनसीएलटी, राइट? ओके, then we have powers of tribunal is listed in section. Now this is something which is very important and that's why I keep telling students कि यार कुछ section numbers तो याद कर लो. अब अगर आपको एकदम भी idea नहीं about the section numbers, straight away 2 marks आपके गए. So some very important section numbers everyone should remember, because ये एक बहुत common question है which I have been telling everyone कि नहीं यार इस chapter में ये question तो याद करके ही जाना है. This is one of the super important questions, right? अब क्या होता है, if you remember the question or if you have been reviewing this particular question, a lot of times you eventually tend to remember the section number also कि हाँ भाई there are a lot of cases कि NCLT क्या करते हैं, they appoint certain persons as directors कि भाई आप report बनाओ and give it to NCLT, right? Powers और क्या क्या होती हैं, removing directors of the company, regulating the affairs of the company, right? Restriction on transfer. तो बहुत सारी powers हैं, they are listed which are important and they're all contained in section 242. Okay, next question. Companies shall not make investment through more than dash layers of investment companies. Now this is one of the easiest question that you can get for 2 marks, my dear. You are blessed, right? What is this? हमने सबसे पहले पढ़ा है यार सब्सिडरी कंपनी की डेफिनेशन इन सेक्शन 2 क्लॉज 87. व्हाट इज इट? लेयर्स ऑफ सब्सिडरीज. Earlier it was only for investment companies, which we eventually read in the chapter of board meetings, but here the very basics you started with this, और वहीं से आपको समझ में आ जाता है कि more than 2 layering on any companies, not just investment companies. Now it is for any company, it is not allowed, right? Okay, the next question. The commission also has the power to impose a fine. CCI, you have read about the penalties, right, of under Competition Act. So one of the penalties is what? Right, if you are entering into a combination, it is your duty to give a notice to CCI, है ना? If अगर आप threshold से meet कर रहे हो, merger आपका हो रहा है and you're exceeding that particular threshold, that means it is a combination and you have to notify it to CCI, right? CCI will either approve, they will either inquire, whatever they want to do, and if they don't respond within a span of 210 days, which eventually has dropped down to 150 days, but you don't have to learn it now, so which is 210 days, not to create any confusion. तो अगर वो 210 डेज तक रिप्लाई नहीं करते हैं, इट विल बी डीम्ड अप्रूवल, राइट? तो इफ वी फेल टू गिव नोटिस, कमीशन हैज द पावर टू इम्पोज अ फाइन व्हिच शैल बी इट्स हायर ऑफ 1% ऑफ टर्नओवर और एसेट्स, राइट? सो टिल दैट amount, that is the maximum amount, a fine which may be imposed by CCI, right? Okay, next question. Wow, again an easy question. Total maximum remittance during a financial year under LRS scheme is. Now LRS is a scheme which is available to all resident individuals including a minor, है ना? तो हर किसी के पास क्या होता है, they are allowed to freely remit. मतलब आप जाओ, आपको $250, of course by providing all the documents that are needed, per financial year you will get it for any current account or permissible capital account transactions, right, or a combination of both. So that comes under LRS. तो कितना है amount? $250,000 per person per financial year including a minor. Next is the judicial authority under SURFACE. Wow, again a very easy question. What is it? DRT, Debt Recovery Tribunal, right? So it has the judicial authority under SURFACE and it actually is empowered to enforce all the provisions of SURFACE. We also have a Recovery of Debts and Bankruptcy Act. Don't get into that. So simple, DRT. The next question. The chairman of IRDA shall hold office for a term of from the date of upon which he enters his office and should be eligible for reappointment. Of course, he is eligible for reappointment. What is the tenure? Now, most of the students are confused between 3 years and 5 years. My dear, it's 5 years, right? So they hold office for a period of 5 years and they are eligible for reappointment. But there's one more thing that you should remember, and that is the retiring age. So until they achieve the age of 65. For the members, it's 62. So here we have slight differentiation amongst the members and the chairperson, and you have to keep this in mind, right? So both the retiring age and the term of office. Okay. So 5 years. Next, IRDA shall, within what tenure after the close of each financial year, submit to central government a report giving true and full accounts of its activities, including the activities for promotion and development of insurance business. See, we have read about a lot of things, and here there might be students who might not be knowing this. There's a question given, the same question is given in the institute's material, but they have not provided the answer, right? So there is some error in that. Now, to be very precise, every, like IRDA, every such authority, including IRDA, they have to prepare books, right? Because they have been given funds, they've been allotted funds for the betterment of a lot of things. They get funds. IRDA has a fund which is being maintained, so there are credits and uses of that particular fund, right? So they prepare books, they prepare financial statements as per the norms which are being laid by CG. We have a section 20. Section 20, which actually talks about furnishing of returns by IRDA. So the returns have to be furnished as CG may direct. First thing. Secondly, they have to prepare a report of all their activities as discussed in this particular question, right? This has to be provided to CG within 9 months from close of financial year. Within 9 months from close of each financial year. So it's 9 months. Within 9 months. Next, if payment to any MSME unit is delayed, this is something that you should remember as a part of general knowledge also. Okay, so delayed payments to MSME. Delayed payments means what? Beyond 45 days from acceptance or deemed acceptance of goods, right? So otherwise there is compounding interest and you are liable. So there are payment deadlines. And if you are procuring goods from MSMEs, all the buyers, please make sure that you make their payment within 45 days of accepting of goods or services, whatever the case be, right? If you don't make that payment within the time limit, then there will be fine, there will be interest, okay? So 45 days is the time limit. Next, we have a case study. Very simple. The case study based MCQs are even simpler. Shri Ramesh is MD of Sunshine Company Limited. The audit is going on and there are many issues which the auditor has pointed out, which are being clarified, but auditor is not satisfied with the answer. So MD wants to know how this auditor can be removed, right? Because he is genuinely asking a lot of questions. So MD wants to know, let us remove this auditor and we'll hire somebody else, right? So auditor is also not comfortable and he threatened to resign. He said, no, I'm not comfortable working like this. You don't provide me information. You don't provide me the documents. I will resign, right? So in such a situation, MD wants a clarification on legal provisions. Can we remove the direct auditor or can he resign? If yes, what is going to be the procedure and all that? You don't have to elaborate. You just have basic MCQs. You read the MCQ and you answer them, right? Now here you get some details. Okay, so here you also have been asked form numbers. So if you have read it in a nice manner, you will remember the form number. But if you have like, why do we need to learn the form numbers, ma'am? Then you will be in trouble, right? So you should at least have this basic idea somewhere in the memory that if I ask you that out of these form numbers, which is the form number, then that should be clicked. Maybe you don't remember it very correctly, but when you look at the options, you should be able to answer. So that's how section numbers, that's how form numbers should be there somewhere in your subconscious memory. It's very important for your paper like this. Okay, so maybe in the descriptive paper or in the descriptive answers you're not writing this, but here you need to write this. Okay, fine. So the auditor appointed may be removed from his office before the expiry of his term only by SR of the company and after obtaining approval of CG by making an application in. Okay, so let me be very quickly, because we have a lot of questions, very quickly let me tell you. We have section 140, right? That talks about removal of auditor, right? So what happens? First of all, we hold a board meeting, then we pass a board resolution. After that, within 30 days, within 30 days of passing the board resolution, what we do is we make an application to CG. That application is an ADT2. ADT1 is for appointment of auditors that you give to ROC, right? ADT2 is about making an application to CG for removal, right? Okay. Now CG approves. CG approves. Once we get CG's approval, within 60 days, what we do is we pass special resolution at general meeting. So first question, what they're asking about making an application in which form to central government for its approval. So you make an application in ADT2. What is the correct answer? ADT2. Okay, let's have a look at the second question, what they are asking. The application shall be made to central government within how many days of the resolution passed by the board? So first we pass the board resolution, and thereafter what we do is we make an application to CG for recording its approval, right? It is made within 30 days. I just told you. So 30 days. Okay, the next one. Sunshine Company Limited shall hold the general meeting within how many days of receipt of approval? So once CG accords you the approval, within 60 days you have to pass SR at GM, right? So it will be within 60 days. I have made a chart also like this. In the chart book, you will find it. Section 140, the chart, right? So if you remember this, it will be very easy for you to answer all these type of questions. The next question. If the auditor has resigned, now this is talking about resignation by auditor. He shall file within a period of how many days from the date of resignation a statement in which form with the company and the registrar. First of all, he has to give it within 30 days. So if you remember the days, there is just one option. So even if you don't remember the form number, eventually you'll get it right, because all the number of days are different. Okay. So this is the correct answer. Fine. I hope this is clear so far. Okay. Now, section B, you have to choose any 5 questions. I will be discussing all 7 questions. I'll not make you write the answers. Of course, this is a quick discussion on MQP and the answers have already been given to you, right? But I will exactly tell you what you should write and how you will get marks. That is the most important thing, right? Okay, so first of all, the very first question that you can see over here, question 2, A and B, part A, 7 marks and part B 7 marks again. Describe the procedure which has to be followed by the company while transferring unpaid or unclaimed dividend from unpaid dividend account to IEPF. So basically we have to write about section 124, right? That whatever is the unpaid dividend, what happens is not all the dividend is paid. First of all, there is a brief I will actually take you through the answer also, because I want you to understand few things, right? Now, if you look at the answer over here, the very first thing, it has been written some introduction. It has been observed that in many cases, few shareholders are not traceable. Now, all this introduction is exactly cut to line from the institute's material. Now, often students think that since it is given in the suggested answer, I have to write exactly like this, otherwise I'll not get marks. This is not so, okay? First thing, whatever this introduction is there, this is not avoided any steps, right? In law, you get step marking. If I get time, I'll even make a video for the same, discussing with you how actually ICMAI is giving you marks. Okay, so we'll discuss that later. But right now you have to understand, you know this very well. A number of times, even when I have told you the concept, I've told you exactly this, that what is unpaid dividend? You have to immediately transfer it to an escrow account, and if it remains over there, you transfer it to unpaid dividend account, right? If it's lying there for approximately 7 years, right? Then what happens? It has to be transferred to IEPF, right? Okay, now all the shareholders can actually claim it from that unpaid dividend account from the company also, and if it is transferred to IEPF, then the shareholders can provide their details and claim it from IEPF also, right? Now, how you should write that you get marks, because there are step marks, bache. Okay, so one by one, every step should be written. Make sure you're writing the answer in points. Okay. Fine. So if you want to add any introduction of yours that yes, of course, all the shareholders are not traceable, right? Or whatever you want to write, that it may so happen that all the shareholders do not claim their dividend, and whatever details are available with the company might not be sufficient to trace them, to track them, right? So some dividend remains unpaid in that account, right? Unpaid or unclaimed, whatever the reason be, right? Now, the very first thing, when it is going to be transferred. So, any money which remains unpaid or unclaimed for a period of 7 years from the date of such transfer is, along with its interest, whatever is there, has to be transferred to IEPF. When you write this, you probably get 1.5 marks. Yes. Okay. So we have certain steps which will, this is because this particular one thing is something which is very important. Okay, and most of the steps will eventually have 1 mark. There will be some steps which will have 1.5 marks. So that's how it works, right? So this is one thing. The second thing, when you have transferred it to IEPF, what you have to do is just a second. The second important thing that you have read in the section is what? In unpaid dividend section number 124, right? That, okay, I have to pay the dividend. If it is paid, great. If it is not paid, that within 7 days, I'll transfer it to a special account in a scheduled bank, right? If it is transferred, good. If it is not transferred, then interest is liable. Now, when it is transferred to UDA, what we're actually talking about, within 90 days, you have to prepare a statement, right? And you have to put it on website also, right? Any person who wants, they can apply, right? So this detail also you will write, no matter what is written over here. One thing. Secondly, the amount shall be remitted to specified branches. Now, other details, what is needed in the process, right? The amount shall be remitted along with the specified branches of SBI or any nationalized bank within a period of 90 days of such amount becoming due to be credited to IEPF. Bank is going to return 2 copies to the company that they have received the amount. Okay, so whatever amount you had, you will remit it to the specified branch of SBI, and they will give you that, okay, fine, we have received the money, right? Now, after that, you will prepare a statement in DIV 5 and give it to IEPF. We have IEPF authority which is actually administering the fund, that okay, these are the receipts, these are the users, right? तो हमें क्या करना है, हमने सबसे पहले देखा कि 90 डेज में हमने वो बना दिया, उसके बाद 7 years तक वो अनपेड रहा, तो हमने आईईपीएफ में ट्रांसफर कर दिया. अब यहाँ पे करना कैसे है आईईपीएफ में ट्रांसफर? वी हैव टू फर्स्ट मेक रेमिटेड टू एसबीआई और एनी नेशनलाइज्ड बैंक, राइट, विद इन 90 days ऑफ सच अमाउंट बिकमिंग ड्यू. मतलब 7 साल के बाद 90 days के अंदर अंदर हमने ये काम किया, बैंक 2 copies हमें रिटर्न कर देगा, ठीक है. एंड उसके बाद वी हैव टू प्रिपेयर अ स्टेटमेंट. कौन सी स्टेटमेंट? DIV 5 की, जहां पे हम पूरे डिटेल्स देंगे, ठीक है. अब अथॉरिटी के पास वो डिटेल्स आ गए. अथॉरिटी मेंटेन्स अ रजिस्टर एंड दे विल enter all the details in that register, and they'll keep on reconciling the amount. Okay, that I have some shareholders have claimed and I have remitted this particular amount, this is still remaining and all that, right? अब कंपनी की इसके बाद क्या ड्यूटी बनती है? that company you also have to maintain a record. सारे नाम शेयर होल्डर्स के, उनके जो लास्ट नोन एड्रेसेस थे, राइट, उनकी क्लाइंट आईडी, फोलियो नंबर, सर्टिफिकेट नंबर, बेनिफिशियरी, व्हाटएवर, ठीक है. जिन्होंने डिविडेंड क्लेम नहीं किया फॉर अ स्पैन ऑफ 7 years, और जिनके डिविडेंड हैज बीन ट्रांसफर्ड टू आईईपीएफ. ओके, दिस रिकॉर्ड यू विल मेंटेन फॉर अ पीरियड ऑफ 8 years. दैट इज व्हाट आपको सारे रिकॉर्ड्स ऐसे ही मेंटेन करने होते हैं ना. सो जब आपने ट्रांसफर कर दिया आईईपीएफ को, फ्रॉम देयर टिल 8 years you will maintain that record, and the authority can anytime inspect that records, right? Or the shareholder can also inspect that records. That is not a problem, right? So this is the entire. अब क्या होगा देखो, मैं आपको बताती हूँ. Basically here you get 1.5 marks. Of course, please add that also, right? Here you get 1.5 marks. Actually here basically you get 2 marks. This is how approximately the division is being done for a question like this. ठीक है, ऐसा जरूर हो सकता है that for this particular step you are getting 3 marks, for this you are not getting any marks, right? For this you are getting 1 mark. थोड़ा बहुत ऊपर नीचे हो सकता है, but broadly this is how the suggested answer is being released for examination checking evaluation. ठीक है, तो अब सोचो अगर आप सिर्फ और सिर्फ इतना लिख के आते हो एंड यू आर एक्सपेक्टिंग दैट व्हाई एम आई गेटिंग ओनली 1 मार्क फॉर अ क्वेश्चन ऑफ 7 मार्क्स, देन ऑफ कोर्स यू विल नॉट गेट मार्क्स. ठीक है, तो आपको लिखना पड़ेगा. ठीक है, एग्जैक्टली यही लैंग्वेज नहीं लिखनी है, बट ऑफ कोर्स ऑल द पॉइंट्स शुड बी इंक्लूडेड इन एन आंसर फॉर इट टू बी प्रेजेंटेबल, राइट? The next question. What is the next question? Explain how the directors are elected by small shareholders appointed under section 151. They have also given you the section number. What else do you need? Right? तो section number भी अब लिखने की जरूरत नहीं है. तो you have to write or reproduce the entire section 151 over here. किसके लिए small shareholders directors होते हैं? Listed companies, right? अब listed companies कब ये करते हैं? So what you can basically write is what are small shareholders, then section में क्या लिखा हुआ है that listed companies may suo motu or on an application of whom, application of or notice of at least 1000 small shareholders, right? Or you can say 1/10 of small shareholders, right? Lower of whatever it is, है ना? अगर ये लोग एप्लीकेशन देंगे या नोटिस देंगे देन लिस्टेड कंपनी हैज टू डू इट, राइट? या फिर लिस्टेड कंपनी सीओ मोटो भी कर सकती है. ठीक है, अब दिस इज हाउ यू choose to appoint. Now there are a lot of points of small shareholders director. Who can become a small shareholders director? They have to propose their candidature, right? So they have to give the company a notice of intention, right? At least 14 days before. आपको 14 days before देना होता है, जिसमें आप small shareholders director, small shareholder, उनका din, उनकी consent, उनकी declaration that yes they are ready, right? Under your signature आप क्या करते हो, that you give it to the company. So this is the another point that you must write. ठीक है, तो मैं यहाँ दिखाती जाती हूँ आपको. First is who are small shareholders. The second is this one. Okay, very important points जो मैं कह रही हूँ आपको. The third is notice. So notice of their intention with the company at least 14 days before the meeting. Fine. Then notice shall be accompanied by, जैसे मैंने आपको बताया, din that he's not disqualified, his consent, everything, right? Now after that what do we have? He may or may not be the independent director, right? So ऐसा हो सकता है. He has to meet the criteria of independence and he shall be considered as an independent director subject to कि वो meet करे independence के criteria को, right? इसका tenure कितना होता है? The tenure is 3 years. Is he eligible for reappointment? The answer is no. He is not eligible for reappointment. There has to be a cooling period of another 3 years, right? So एक बार का tenure उनका क्या होता है? 3 years. After expiry, he cannot be associated for the next 3 years, right? और क्या क्या हमने पढ़ा है? इफ यू रिमेंबर माई चार्ट देयर विल बी कंप्लीट सोल्यूशन, आपको पूरा मिल जाएगा. और हमने क्या क्या पढ़ा है कि जो एसएसडी होता है, ही कैन बी एन एसएसडी इन मैक्सिमम 2 कंपनीज, और वो दोनों कंपीटिंग बिजनेस में नहीं होने चाहिए, राइट? नो रीअपॉइंटमेंट इज अलाउड फॉर एसएसडी. दैट इज समथिंग दैट आई हैव ऑलरेडी टोल्ड यू, राइट? So such director shall not be liable for rotation, tenure 3 consecutive years, not eligible for reappointment. So all these are, whatever I'm highlighting, shall be considered as independent director subject to his eligibility criteria meeting, right? Now, not more than 2 companies at the same time, not in competing business. Fine. So all are these important points. Now he has to vacate if he incurs disqualifications, if vacation is attracted under section 167, or if he ceases to meet the criteria of independence. That's why I said the other part also regarding to independent director. ठीक है, तो ये मैंने आपको समझाया भी है इन डिटेल कि हाँ भाई कैसे होता है, क्यों इंडिपेंडेंट डायरेक्टर को यहाँ से जोड़ा गया है, राइट? So I hope this is clear. So all these points have to be stated. विद रिस्पेक्ट टू स्मॉल शेयर होल्डर्स डायरेक्टर? वेरी सिंपल क्वेश्चन, डायरेक्ट क्वेश्चन है, कुछ दिमाग लगाने की ज्यादा जरूरत है ही नहीं. अगेन another direct question. What is the direct question? Describe the powers of board to be exercised by the board by means of resolution. या तो बहुत ही सिंपल है, सेक्शन 179 पूरा का पूरा रिप्रोड्यूस कर दो, है ना, और उसमें हमारी बिग पावर्स होती हैं, है ना, बोरोइंग, इन्वेस्टमेंट, और तो वो क्या होती हैं, दे कैन बी डेलीगेटेड ऑल्सो, दे कैन बी डेलीगेटेड ऑल्सो. तो आपको पूरी की पूरी चीजें क्या कर देनी है, लिख देनी है. व्हाट आर द पावर्स ऑफ बोर्ड? बोर्ड इज एंटाइटल्ड टू डू ऑल दैट अ कंपनी कैन, है ना. तो जो कंपनी कर सकती है वो यहाँ पे बोर्ड भी कर सकते हैं. एंड बोर्ड जितने भी पावर्स अपने एक्सरसाइज करते हैं वो कैसे करते हैं? थ्रू अ बोर्ड रेजोल्यूशन. देयर आर सर्टेन पावर्स विच कैन बी एक्सरसाइज्ड ओनली एट अ बोर्ड मीटिंग. अदरवाइज क्या होता है, बोर्ड कैन टेक एक्शंस एंड पास रेजोल्यूशंस. कैसे? by circulation also or at the board meeting also, right? So powers of board which are given in section 179 की वहाँ पे आपको क्या करना है, एक ड्यूली बोर्ड मीटिंग जो है उसको कन्वीन करनी है और वहाँ पे आपको वो सारी चीजें करने हैं. व्हाट इज इट? चलो let's have a quick review at that also. So in general, certain things, as I mentioned, board shall not exercise any power or do any act which has to be done by company in general meeting. So we all know that Companies Act has reserved certain powers which can be conferred at a general meeting by the shareholders only. Like if you want to alter your articles of association, the board cannot do that. The company can do that, है ना. तो although in general हमारे पास क्या concept है that whatever a company can do, the board of directors are entitled to do that. However, whatever you are doing, that will be within the act, within the powers stated in memorandum, articles or regulations or the OR or SR passed at general meeting, है ना. तो within that ही आप करोगे, ठीक है. ओके, नाउ पावर्स ऑफ द बोर्ड टू बी एक्सरसाइज्ड बाय द बोर्ड बाय मींस ऑफ रेजोल्यूशन. ठीक है, क्या है? टू मेक कॉल्स फॉर शेयर होल्डर्स, टू ऑथराइज बाय बैक, इशू सिक्योरिटीज, बोरो मनीज, इन्वेस्ट फंड्स, ग्रांट लोन्स. नाउ दीज आर द थ्री पावर्स जो मैं बोलती हूँ बिग पावर्स. BIG, borrow, invest and grant loans, they can be delegated. Okay, they can be delegated to approve financial statements, diversify business, approve amalgamation and take over a company. ठीक है. Other matter as may be prescribed. What are the matters which have been prescribed? There are certain additional powers which have been prescribed through the rules that yes, the board can make political contributions. पहले तो इस पे बहुत ज़्यादा restrictions हुआ करते थे, अब तो वो भी नहीं है. ठीक है, तो पॉलिटिकल कंट्रीब्यूशंस खुल के बिंदास कंपनीज कर रही हैं बिकॉज गवर्नमेंट इज मेकिंग दीज लॉज ना. तो गवर्नमेंट चाहेंगे यार इस पे क्यों हम लगाएं, ये तो हमारे लिए ही हो रहा है. सो नोबडी ऑब्जेक्ट्स एक्चुअली. अर्लियर द लॉ वाज स्टिल थोड़ा सा डिफिकल्ट. To appoint or remove KMP, to appoint internal auditors as well as secretarial auditor. ठीक है, और delegate powers ये मैंने आपको ऑलरेडी बता दिया. किसको delegate कर सकते हैं? It can be delegated to any director, it can be delegated to a committee, it can be delegated to managing director. ठीक है, तो किसी को भी आप delegate कर सकते हैं. If we are talking about a branch, it can be delegated to that principal officer of the branch. So that is what you have to write. Very 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 simple answer, right? चलो. ओके, देन वी हैव द नेक्स्ट क्वेश्चन. ये जो आपका क्वेश्चन है, अरे बच्चे पढ़ के काफ़ी मेरे पास एक आध मैसेज आए कि मैम ये क्वेश्चन क्या है, समझ में नहीं आ रहा. यार दिस इज अ क्वेश्चन स्ट्रेट फ्रॉम योर स्टडी मटीरियल. बहुत सिंपल सा डायरेक्ट सा क्वेश्चन है. एंड दिस इज नॉट समथिंग आपके स्टडी मटीरियल में. देयर आर लॉट ऑफ केस स्टडीज given at the end of the chapter. Some case studies are solved, some are unsolved. तो ये तो वाली क्या है, ये solved case study आपकी इंस्टीट्यूट ने पूछी है, मतलब बुक में दी हुई है, और एज इट इज उठा के यहाँ पे MQP में भी दी हुई है फॉर रिविजन पर्पस. क्या लिखा हुआ है? ABC Limited is a public unlisted company with 50 crore equity capital of 10 each. It has 70% equity of a company called BCG Limited. मतलब BCG Limited क्या हो गई, इसकी सब्सिडियरी हो गई, राइट. We have ABC Limited and इनके पास 70% इक्विटी है of BCG Limited. Now this is also a listed company. ये अनलिस्टेड कंपनी है. ये क्या हुई, लिस्टेड कंपनी. तो एक लिस्टेड कंपनी को इन्होंने टेक ओवर, मतलब एक लिस्टेड कंपनी को अपनी सब्सिडियरी बना लिया है. ठीक है, with equity capital of 20 crores divided into shares of 10 each. ABC Limited and BCG Limited have decided to merge. इन्होंने सोचा कि यार क्यों दूर दूर रहना, एक तो हो ही चुके हैं हम लोग इतने, करीब तो आ ही चुके हैं, अब एक ही हो जाते हैं, ठीक है। अब आपसे पूछा जा रहा है कि क्या ये दोनों मर्ज हो सकते हैं या नहीं हो सकते हैं। सो देयर आर prima facie 4 direct questions, and when you have these point to point questions, be very happy, because in these cases you have to write less and you get more marks. तो आपको इसमें concept नहीं लिखना होता है, ठीक है। 1-2 lines में you can always add concepts to make your answers more professional and increase your chances of getting marks, ठीक है। क्योंकि अगर आपका थोड़ा भी बहुत भी कुछ 19-20 होता है and you've written that, so you get marks, ठीक है। तो थोड़ा एग्जामिनर उसको देखता है, तो लिखो, अच्छी बात है, बट हियर यू हैव टू राइट डायरेक्टली टू व्हाट इज बीइंग आस्क्ड. So is the decision to merge in order? Of course, why not? Why is the merger a problem? Mergers and amalgamations का हमने पूरा चैप्टर पढ़ा है. If you are following all the provisions, if everything is in order, right? आप लॉ के अकॉर्डिंग कर रहे हो, कंपनीज एक्ट के हिसाब से कर रहे हो, then you can go for merger. But this is not something which is called as a fast track merger. फास्ट ट्रैक मर्जर जो स्मॉल कंपनी वगैरह के लिए हम करते हैं, बिकॉज दिस इज नॉट अ स्मॉल कंपनी. वी आर टॉकिंग अबाउट पब्लिक कंपनी, वी आर टॉकिंग अबाउट होल्डिंग, सब्सिडियरी एंड ऑल दैट, राइट. सो यहाँ पे जो नॉर्मल मर्जर का हमारा प्रोसीजर है, दैट हैज टू बी फॉलोड, एंड इफ यू आर फॉलोइंग दैट पर्टिकुलर प्रोसीजर, ऑफ कोर्स it is a valid merger and it is in order, right? Is the merger to be approved by shareholders of each of the companies? Now, if you remember the provisions of merger, you will easily be able to write. क्या होता है इसमें? Basically, you need two approvals, right? You need the approval of shareholders also, and you need NCLT's approval also, right? So shareholders or whoever the case involved is, they have to approve 3/4 in value, right? So you need to obtain their consent. Now, if you try to recall the entire thing, right, what happens is a scheme is being formulated, right? Then an application under section 230 is being made. However, the process of approval and that is all being given in section 232. So both the sections are actually interlinked. Now, what happens is there will be a scheme, right? There will be consent of members or creditors, majority in number representing 3/4 in value, right? So that is what is required. You get their approval, you give it to NCLT. NCLT will consider the objections, and thereafter they approve the scheme, right? So there is one scheme which is being formulated. Why am I insisting on scheme and scheme? Because if you look at the answer, you'll be like, ma'am, there are 5 answers given and 4 questions asked, right? So when institute has actually picked up this question, they have copied the answer correctly, but in the question they have missed out one point, which is part 2. And it only says, is the scheme necessary? The answer would be yes, of course the scheme is necessary, right? You can add the details why the scheme is necessary, right? Or in what manner the scheme is being formed, right? So there is a scheme which is being formulated, it has to be approved. Scheme of what? Scheme of amalgamation, merger, reconstruction, whatever we are talking about, right? So is the scheme necessary? The answer is yes, the scheme is necessary. The third one comes that whether the merger has to be approved by the shareholders of each of the companies. Yes, the scheme has to be approved by 3/4 majority of shareholders. 3/4 majority in number, 3/4 in value, right? Majority in number representing 3/4 in value. That's how you need to actually write. What happens if few shareholders do not consent? Now, we have read a separate section also about the shareholders of dissenting or the dissenting shareholders. The shares of dissenting shareholders, they may be taken over, right? So whoever does not agree to the scheme of merger or amalgamation does not really have a choice, because we have also read about section 235, which talks that there is a power to acquire shares of dissenting shareholders. So the transferee company gives an offer, and they may accept it, they may reject it, right? So in such a situation, their shares will actually be taken over. What choice you have or what option you have is you can apply to tribunal. Okay, you can apply to tribunal. That is it. Fine. So what happens if few shareholders do not consent? They do not have a choice. They have to accept the decision of the majority, right? Only under section 235 they may apply to tribunal. Does require order of tribunal? Yes, of course, you need approval of NCLT. I already told you this, right? So you have to get the approval of NCLT. How do you get the approval? You write that. I would sincerely urge and suggest that although the answers are absolutely straightforward and yes, 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 you please write a brief justification also. Okay. Moving to the next question. Question number 4A. The Board of Directors of Best Consultants Limited, registered in Kolkata, proposes to hold the next board meeting in the month of May 2024. They seek your advice in respect of the following matters. Can the board meeting be held in Chennai when all the directors of the company reside in Kolkata? And is it necessary that the notice of board meeting should specify the nature of business to be transacted? So these are two very basic things, but the problem comes when the students actually confuse it with the general meeting. There is a different requirement for general meeting, and here is a different requirement, and we are talking about board meeting, right? So holding a board meeting is not a barrier, right? The place is not a barrier, right? You can hold the board meeting anywhere in India. That is not a problem. And even outside India. So it may be held at the registered office, it may be held at any place in the city, outside the city, in India, outside India, right? So it does not matter whether you're holding the board meeting in Chennai or Kolkata, it may be held at all. There's no issue at all. The members who cannot actually attend it in person or physically, there is also an option to attend the board meeting through video conferencing, right? So there will be a roll call and the entire procedure. You already know about that, right? Earlier there were certain matters which could not be taken up at a board meeting through video conferencing, but post COVID that has also been removed. Okay, the second thing, that do we need to specify what business is going to be transacted, or in short we can say, do we need to state the agenda in the notice of the board meeting? The answer is no. So the section nowhere tells that the notice has to be giving the agenda, first of all. However, as a part of good secretarial practice, it must be given. So you will elaborate this and you will write it. Very simple. Question 4B. United Social Services Limited is a company which is formed by 10 professionals with 1 lakh paid up capital by each promoter. The company intends to give various services to NGOs and other social sector organizations with a marginal profit. So they're profit making entity. Okay. Though the registered office is in Delhi, the company wants to work pan India. Fine. Critically assess the following perception and advise the management. The company claims it is a non-profit company. Firstly, the contradictory thing that you are making profit, right? Secondly, a non-profit company may generate surplus. That is not a problem. You may render services, but then the prima facie requirement is to obtain license under Section 8 and register yourself as a not-for-profit making company. Only then you will be called as a non-profit company. Otherwise, you will not be called as a non-profit company. Secondly, if not, can it be converted as NPO? The answer is yes, it can be converted as NPO. There is absolutely no problem. But then here, because you have only 4 points given, you must write the process of conversion. Although it is not asked, if yes, how? If this was asked, we would have been very sure that we have to write the process. But then, okay, in the next part, it is actually given what is to be done for conversion. Even if it was not given, then also briefly, you must have written how do we convert. In briefly, like just in 2 lines, by making an application for license, we have INC 12, right? So we make an application. The existing companies can make an application and they can get the license. They have to give the required. So now it is being asked what is to be done for conversion. You have to write the entire steps. The first requirement is that a private or a public company can convert itself into a Section 8 company. That is not the problem. But first thing, you will accordingly alter your MOA and AOA. Fine. So you will have only the objects which are allowed for an NPO, right? Secondly, you have to make an application in INC 12 for obtaining license. Right? For obtaining license, you need to submit certain documents. What are the documents? Statement of assets and liabilities. You also need to give a public notice, right? And ROC might require other information. So, a statement of income and expenditure, right? Expected. estimated, right? So all these documents you will submit, and then once you get the license, ROC will issue you a new certificate of incorporation, and once you're converted, then would the promoters get dividend out of profit? The answer is absolutely no. Section 8 companies are prohibited to distribute dividend to its members, right? And whatever surplus is being generated, whatever profit is being generated, you have to plow it back to or for the objects of the business only. Right? Okay. Next question, question 5. A Jyoti Industry is a public limited company. Due to some insolvency resolution problem, the factory and office were closed. 2 accounts officer dealing with the finalization of accounts left the company in quick succession, and accounts could not be prepared. So we had 2 accounts officers, the accounts could not be prepared. There was some financial distress, the accounts could not be prepared. What happened? Prima facie, the question looks like that it is a question of IBC, but no, my dear, it is not a question of IBC. You read the question in entirety. That is why one more suggestion over here. As a student, when you read such question and you look, okay, oh my God, it is of IBC. IBC is the topic which I've left. And immediately you leave the question. The question is very easy and it is not related to IBC. So please read the question carefully. It is likely that the financial statements will not be placed within the last date of AGM because they cannot make the accounts ready for certain reasons, right? What choice do you have? Analyze the legal provisions. Accounts are not ready and cannot be placed in AGM. ठीक है, ये situation है. You have to analyze the legal provision कि भाई accounts ready नहीं हैं, they cannot be placed in AGM. तो अब हमें क्या करना चाहिए? AGM to be deferred after 30th September. Accounts are ready, but AGM could not be held. AGM held, accounts placed but not approved. So we have been given these 4 situations और इनमें हमें legal provisions को क्या करना है? Analyze करना है. तो सबसे पहले accounts are not ready and cannot be placed in AGM. So what will happen? Supposedly AGM is conducted because cannot be placed in AGM का मतलब क्या है कि AGM तो हुई और वहाँ पे accounts ready नहीं थे. So वहाँ पे उनके सामने हमने members के सामने we did not present the financials. So what will happen is AGM will be adjourned. AGM will be adjourned and before or within 30th September it will be held, and then what will happen? Then we will place the accounts because accounts are not ready. तो अभी place हुए नहीं हैं, तो वो एजेंडा जो आपका AGM में होना चाहिए था वो हुआ नहीं, तो AGM adjourn हो जाएगी और बाद में होंगे तब कर लेंगे. पहली चीज. दूसरी, AGM to be deferred after 30th September. Well, yes, it can be deferred. Extension has to be sought from ROC. For the first AGM, you don't get any extension because already the time limit is till December, right? For second and subsequent AGMs, you can seek extension. तो आप genuine grounds पे ROC को apply करोगे और extension ले लोगे, पर इसका मतलब ये नहीं है कि हम 1 October को ROC को application देंगे that I want extension. No, you have to seek extension before 30th September only, है ना? एक्सटेंशन पहले मांगा जाता है, बाद में नहीं कि अब तो सब हो चुका है जो हो चुका है, अब तो सूली पे लटकाने वाले हो, पेनलाइज करने वाले हो, तो हम जाके हाथ जोड़ के बोलेंगे एक्सटेंशन दे दो दे दो दे दो. नहीं. थर्ड इज अकाउंट्स आर रेडी बट AGM कुड नॉट बी हेल्ड, तो यू हैव टू होल्ड द AGM, राइट? इफ AGM कुड नॉट बी हेल्ड तो हमारे पास एक आता है पावर्स ऑफ ट्रिब्यूनल, है ना? तो ट्रिब्यूनल आपको डायरेक्शन देता है टू होल्ड AGM. अदरवाइज यू हैव ऑलरेडी कॉन्ट्रवीन्ड द लॉ. आपको AGM उतने टाइम के अंदर अंदर करनी चाहिए थी या एक्सटेंशन लेना चाहिए था, आपने दोनों में से कुछ भी नहीं किया. सो यू ऑलरेडी वायलेटेड टू लॉ एंड यू विल ऑलरेडी बी अट्रैक्टेड टू द पेनाल्टी. ठीक है, अब आप और चीज़ें क्या है भाई, कोई भी मेंबर ट्रिब्यूनल के पास जा सकता है, ट्रिब्यूनल विल गिव द डायरेक्शन टू होल्ड AGM. दैट कैन बी डन, और यू कैन ऑफ कोर्स मेक एन एप्लीकेशन टू ROC. Next is AGM held, accounts placed but not approved. तो AGM हुई है, अकाउंट्स आपने सामने रखे हैं पर वो अप्रूव नहीं हुए, तो जो प्रोविजनल अकाउंट्स होते हैं दे हैव टू बी सबमिटेड टू ROC. देन देयर विल बी एन एडजर्न्ड AGM और उस दिन जो अकाउंट्स अप्रूव होंगे वो आप फिर से ROC को दोगे. ROC विल इनिशियली रजिस्टर योर अकाउंट्स एज प्रोविजनल रिकॉर्ड्स, और जब आप उनको फाइनल रिकॉर्ड्स दे देते हो देन व्हाट दे विल डू इज दे विल keep that as final, right? So even if financial statements are not adopted, then also you have to file the financial statements. Filing of financial statements we have read in section 137. ठीक है. Question 5. Question 5B. Mr. Ajay, an advocate, is in the business of providing professional services like filing of petitions before courts and tribunals. Mrs. Sonali, wife of Mr. Ajay, is a registered IP with IBC. Okay, so we have Ajay, who is an advocate, and he provides professional services like filing of petitions. And then we have Mrs. Sonali, who is an IP. Mr. Ajay, in his capacity as an advocate, filed many applications relating to admission of corporate debtors before NCLT, and his wife, Mrs. Sonali, being IP in her own professional capacity, acts as IP in all the cases her husband takes up. Mrs. Sonali, within 6 months of becoming IP, accepted 15 such assignments. She does not have any prior experience as IP. While considering one such application for initiation of CIRP, NCLT observed that the fees charged for acting as IP is exorbitant. Mrs. Sonali contracted with the applicant to not only act as IRP but also as RP in all the 15 assignments that she accepted. With reference to the above mentioned facts, analyze the situation and discuss answer with reasons of the following questions. Is Mrs. Sonali right in accepting the assignments? Well, although we are not supposed to read the entire code of conduct for IPs कि कैसे उनको behave करना चाहिए या क्या उनको करना चाहिए, one basic thing is what we need to understand, that you have to maintain independence, है ना? You have to maintain honesty, you have to maintain integrity in all the assignments that you are taking up. ठीक है, तो अगर आप ऐसे assignments, if it is pure reference and the client is basically evaluating what is required, what is not required, how competent she is, it is a normal case, they are satisfied with the competence and independence, and it is not biased, then she may accept. Otherwise, in the given situation, prima facie what appears is that it is slightly biased, right? It is affecting her independence, so it is not correct for Sonali, Mrs. Sonali, to accept that. Okay, in general. Secondly, IBBI has issued a show cause notice to Mrs. Sonali based on the adverse remarks made by NCLT. Is IBBI empowered by the code to issue a show cause notice even without a complaint made against it? So yes, of course, IBBI, it's IBBI. ठीक है, तो IBBI बिल्कुल empowered है. IBBI is the authority which is actually meant to overlook and oversee the professionals, है ना? तो NCLT ने कुछ मतलब कोई कंप्लेंट आई हो या नहीं आई हो, IBBI की नॉलेज में अगर आएगा एंड इफ दे हैव रीजनेबल ग्राउंड्स टू बिलीव कि नहीं भैया ये IP जो है ये ठीक से बिहेव नहीं कर रहा है या इसने कुछ गलत किया है, तो डिसिप्लिनरी एक्शन जो हम पढ़ते हैं ना, तो डिसिप्लिनरी एक्शन मे बी टेकन अगेंस्ट दैट पर्टिकुलर IP. ठीक है, और अगर डिसिप्लिनरी एक्शन पेंडिंग होता है तो वी हैव रेड कि भाई उसको अपॉइंट भी नहीं किया जाता है, राइट? सो IBBI हैज फुल पावर. Now, assume that out of 15 assignments, Mrs. Sonali accepted 2 are listed companies, 3 are unlisted public companies, and 10 are private companies. Is there any limit? तो लिमिट तो कोई है नहीं, लिमिट तो हमने पढ़ी नहीं है. लिमिट तो हमने डायरेक्टरशिप्स पे पढ़ी है, ऑडिटर पे पढ़ी है, सीलिंग ऑन ऑडिट्स, है ना? यहाँ पे IP पे तो हमने ऐसे कुछ पढ़ी नहीं है, और यही सेम चीज़ आपको लिखनी भी है. ठीक है, तो बस अगर मैं बोलूं कि मेरे ऊपर कोई लिमिट नहीं है, आई कैन टीच ये भी, मतलब मैं बहुत सारे सब्जेक्ट्स पढ़ा सकती हूँ. ठीक है, ऑफ कोर्स भाई अगर मैं बात करूँ कि ये करिकुलम है जो मुझे पढ़ाना है, दिस इज समथिंग दैट आई हैव रेड, दिस इज समथिंग दैट आई हैव एक्सेल्ड इन. भाई एज अ स्टूडेंट मेरे अगर 80 मार्क्स आए हैं इस पर्टिकुलर कोई सब्जेक्ट में, प्रोफेशनल सब्जेक्ट में, सो आई बिलीव आई हैव गेन्ड दैट नॉलेज, आई स्टिल हैव इंटरेस्ट इन दैट नॉलेज, आई कीप अपडेटिंग माई सेल्फ, सो डेफिनेटली मैं पढ़ा सकती हूँ. बट क्या मुझे पढ़ाना चाहिए? द आंसर इज नो. वाई नो? बिकॉज देयर शुड बी sufficient time which I can devote. So if I am teaching just one subject, I can be better at it. I can continuously update myself. I can find better ways to explain a particular concept. If I have too many things on my plate, I will always be like, इसको भी पूरा टाइम नहीं मिल रहा है, इसको भी पूरा टाइम नहीं मिल रहा है ना? तो नहीं करना चाहिए. So the same goes for the IP also, although there is no limit, but if you are a professional, accepting too many assignments which you're not able to justify should not be done. Okay, fine. Now, question number 6. Question number 6, of course, I'm not discussing. Why am I not discussing? Because it is a direct theoretical question. Features of corporate governance, you know it very well. You have to exactly reproduce. If you write anything else, you're not going to get marks. Okay? तो फीचर्स ऑफ कॉर्पोरेट गवर्नेंस जो मैंने आपको पढ़ाए हैं वो वैसे ही आपको लिखने हैं. ट्रांसपेरेंसी, then enhancing value of enterprise, accountability, innovation, stakeholder recognition, everything, right? The same goes for the next one, BI. You have been asked a direct question कि कौन से हमारे BI tools and applications हैं और इनके benefits क्या हैं. तो हमने जो different types of BI tools पढ़े हैं, if you are somebody who does not understand कि मैम ये mobile BI क्या होता है, real time BI क्या होता है, maybe you have taken classes, भूल गए हो या पहले लिया था नहीं लिया था, जो भी है. So you can also refer to the marathon, और marathon में बहुत quickly one line में मैंने आपको ये बताया कि what exactly this is. ठीक है, तो आपको समझ में आ जाएगा लोकेशन इंटेलिजेंस क्या है, कोलैबोरेटिव बीआई क्या है, दिस यू विल अंडरस्टैंड. ठीक है, सो यहाँ पे आपको सारे के सारे टाइप्स ऑफ बीआई लिखने हैं एंड देयर आफ्टर यू हैव टू स्टेट द बेनिफिट्स दैट यू गेट फ्रॉम बीआई. ओके, नेक्स्ट यू हैव अगेन क्वेश्चन नंबर 7 also is something which is a direct question. Question number 7, what is it? Explain the term connected person in context of insider trading. तो connected person होते हैं हमारे पास and then we have deemed connected person, right? है ना, who are deemed to be the connected person. तो आपको दोनों की definition यहाँ पे लिखनी है. Connected persons कौन होते हैं भाई? Who have been associated with the company. Just a second, I'll show you. Connected person. So who is connected person? Person who is or has during the past 6 months associated with the company in any capacity, right? So we have some concept, very deep concept called as UPSI. What is UPSI? Unpublished price sensitive information, right? Had this information been released, it would result in fluctuation of prices. Like we have any financial information, we have information relating to dividend, right? So all that is UPSI. So if any person was associated with the company, need not be an employee, right? He may be somebody who has entered into a contract with the company, but he was associated with the company in the past 6 months and he was associated in such a manner that he had some access to UPSI, so he will be treated as connected person. Now there are some deemed connected persons, so these persons are considered to be connected person unless something else is established. The banker of the company, member of board of mutual fund, right? Stock exchange official, immediate relative of that connected person, right? What is immediate relative? It is the spouse is covered, parents are covered, sibling, child, right? These are immediate relatives. Holding associate, subsidiary, right? So all these are what? Covered. Okay, intermediary, the employees, investment company, trustee company, right? Clearing house. So all that is covered and they are treated as deemed connected person. Fine. Okay, so you just have to write the definition over here. The next one is, what is combination under Competition Act? So again, a very simple question, and how is it being regulated? I have told you that you have read a lot of things about combination, how it is regulated. First thing, because it is regulated, right? Combinations are not something which is being prohibited, right? We have abuse of dominant position, which is absolutely prohibited. We have anti-competitive agreements which are considered to be void and are not allowed, but combinations are allowed. It's just that they are being regulated. So we have read about regulation of combinations. We have also read about investigation into combinations, right? Orders against combination, penalty. And there are a lot of things that we have read about combination. So here what they're asking is, they're asking about regulation. What is regulation? How is it being regulated? That if you are entering into a combination, you must notify it to CCI, right? And CCI will accord you the approval. So you have to write about the 210 days deemed approval. You have to write about In fact, I have made you written. If you are my regular student, I have exactly made you write this particular question in the class also, right? So how is it being regulated? Okay, so what is combination? Let me show you that also very briefly. Right, here we have. So if there is a company which is acquiring share assets or control of any enterprise, and post acquisition together your assets or turnover exceed a particular threshold, then that results in combination. What is the threshold? Although there are three things or three types of thresholds given, but you have to read only one, and that is, so if you are an individual, you don't belong to any group, after acquisition, your assets in India exceed 2000 crore, or your turnover in India exceeds 6000 crore. If you are operational in India as well as outside India, then US $1 billion, US $3 billion. But in this, you also have to make sure that you know that out of this, at least 1000 crores in India should be there, right? 1000 crores in India and 3000 crores in India, rupee, right? 1000 crore and 3000 crore, both are same here also and here also. Okay. Right? And for group, exactly into 4. Right? So you must learn this limit. This is very often asked as a MCQ, as a descriptive question, and you have to write it. Ma'am, can we write it like this? The answer is no, don't write it like this. Although you can, you would probably get marks, but you won't get full marks. Okay, so don't write it like this. Write it properly. What is the problem? If you have understood, you have to write it in your own words. And you know this, right? So the combined assets of the enterprise, if they exceed 2000 crores in India, or the combined turnover exceeds 6000 crores in India. Fine. Firstly, write about individual. Secondly, write about group. Then first line you have written. Then if the enterprises have assets or turnover outside India also, then the combined assets exceed 1 billion US dollar, or the combined turnover exceeds 3 billion US dollar. Okay, so that is how you will write it. Fine. And we have the last question. Analyze the aspects which remittances are prohibited. Discuss what facilities are available to entities other than individuals. So we have remittances which are prohibited. You cannot trade outside India, right? Then there are certain prohibited magazines, sweepstakes, and all. For that, you will not get remittance, right? Then we have remittance for okay, it's already given over here, right? So we have all these prohibited items under LRS, which you have to state that these are the items which are prohibited. A very common question which has been asked frequently. And the next part is discuss what facilities are available to entities other than individuals. So for individuals, resident individuals, under LRS, we have this 250,000 US dollar, which states that you can use this to transact any current account transaction or permitted capital account transaction. But when we talk about other than individuals, then this is the limit that we have, right? So for other than individuals, the remittance is slightly different, right? Again, if you don't know this, you can watch the marathon and understand the concept, because such type of questions, if you don't understand the concept, it will be difficult for you to write. Okay, and once you understand the concept, it will be like very easy. The next question, or the last question, I would say, is again a very repetitive question which has been asked in examination multiple times, and that is registration of ARC. Registration of asset reconstruction companies, right? So what is the basic requirement that you have to state, and all the points? Clear? Okay. This is a direct question, so I'm not getting into much detail. And wish you all the very best. Stay tuned. There will be a lot more videos coming up for your upcoming December 24 examination. Thank you.